Ethics Untangled is made by the Idea Centre at the University of Leeds. It's a podcast about the difficult ethical questions we face in everyday life. In each episode, I interview someone, usually a philosopher, who's spent time thinking through one of these questions, and we try between us to work out what's going on. Alex Batesmith has had a fascinating career. After starting as a criminal barrister in Leeds, he went on to work as a United Nations prosecutor in Cambodia and Kosovo, working on cases involving genocide, crimes against humanity and war crimes. He's now a legal scholar working at the University of Leeds and has been researching the values and motivations of international criminal lawyers. In this conversation, we discussed the idea of cause lawyering. Cause lawyers are lawyers who practice law primarily because of their moral, political, or ideological commitments. An example of someone who has arguably been a cause lawyer is the UK's new Prime Minister, Sir Kier Starmer, whose previous career as a human rights lawyer appears to have been motivated at least partly by some broader moral commitments, including opposition to the death penalty, for example. It's interesting to consider how, in general, this kind of outlook complicates the ethical framework under which lawyers operate, which traditionally balances duties to the client with duties to the court and to the rule of law. Alex, welcome to the podcast.
Thanks very much, Jim. Delighted to be here.
And Alex, your career history is an interesting one. So you started off, I guess, as a legal practitioner, as a lawyer, and then became an academic working in law. So could you tell us a bit about your career history and how you ended up where you are now?
Certainly, of course. So I've come full circle, really. Started off in legal practice as a barrister here in Leeds.
Right.
And now I'm a lecturer in legal profession at the School of Law here in Leeds. But before that, it might be useful just to sort of reflect a bit on why I became a lawyer in the first place, because that's one of the things I'd like to talk a bit about, what motivates people to want to become a lawyer. And for me, I didn't ever have this burning ambition from being a kid to always want to be a lawyer.
Yeah.
I never was particularly good at arguing. But it was when I was doing my A-level English and I read the book Schindler's Ark by Thomas Keneally that became the well-known film Schindler's List, which listeners will know was about an industrialist in Germany at the time of the Holocaust and trying to save so many people who were working in his factory. And I became engrossed in the idea of what makes people tick who do that, who do the saving, and also what makes people tick who are doing these terrible things. And what happens, how can we bring these people to justice? How can we stop it happening again?
Right.
So I sort of developed that really in my mind and started being interested in studying and thinking about rights and wrongs, good and evil, all those sort of idealistic things. And I went to a conference at Cambridge University on the death penalty, and that was when I first started hearing the arguments for and against this sense of good and evil and how we combat human evil with domestic punishment.
Right.
So I applied to study law and ended up studying law at Cambridge, actually. And still didn't quite have an idea of what type of lawyer I wanted to be other than to somehow do good. I hear a lot of my students now saying the same thing. Why do you want to be a lawyer? Well, I just want to help people, to do good, to change things, that sort of idealistic impulse that a lot of people have.
Right.
And I did some work experience with a solicitor and with a barrister here in Leeds, close to where I grew up in East Yorkshire, and I just got on really well with the barrister and didn't get on quite so well with the solicitor. The barrister was very much in the mould of the crusader that was doing good in a way.
Right.
He was wearing a cape and he fights crime, to paraphrase the secret barrister. And I just liked the idea, even though I wasn't necessarily somebody who was naturally au fait with argumentation and with conflict. I found myself applying to the bar and wanting to work within criminal law specifically as a human area where I could perhaps do some good.
Right.
That was the ideal. The reality didn't quite match that.
Right. Okay. So, I mean, that's kind of what we're here to talk about today, right? It's that kind of, the motivations which people have for becoming lawyers in the first place, and then the motivations that they then kind of bring to their legal practice, and ways in which maybe that sometimes does match with reality, but sometimes doesn't match with the reality of what they end up doing, right?
Yes.
So yeah, it's interesting that the way you described the way you came into the profession it does sound very idealistic. And you've been engaged in a project where you've been interviewing other lawyers about their motivations, right?
There's a bit in between that I should perhaps talk about as well. Sure. So I was a barrister for 10 years, and I'm nearly 10 years, and I think halfway through that 10-year period, I started to get disillusioned because it wasn't the vehicle for being a minister of justice that I expected it would be. Of course, we're all trained as barristers to be dispassionate, to take your emotion out of being in practice, which I'll come back to in a while, and to always either prosecute fairly or defend your client to the fullest within the bounds of what is permissible. And I found that I wasn't so much helping people as necessarily sort of competing with other colleagues who would be getting better and bigger work because they were playing golf with the right people, or because they were having connections that I thought were not really very fair. Mm-hmm. And somebody that didn't have any legal connections, I was the first in my family to go to university. I just felt a bit sad about that. And I'd kept in touch with the person I met right at the very beginning when I was at university, who later became a judge. And he became a judge in Kosovo for the United Nations. Right. So I went out to visit him, which very soon after the Kosovo conflict, the Kosovo part of the Yugoslav war. And he said there's a job going as a prosecutor here for the UN. And I thought to myself, well, this sounds incredible to be able to reconnect with the motivations that I originally had when I wasn't really getting it here as a barrister in Leeds. And I also say perhaps should reflect that it wasn't just the fault of if we can call it fault of the system. I think it was my own, perhaps overly idealistic approach to what the law might be. So I applied and got the job, and I was a UN war crimes prosecutor in a town called Gilan, and then in Pristina, in the capital. And I was given my own case files, a white Land Cruiser, told to go and prosecute in various far-flung courts with a translator, and it was exhilarating, absolutely exhilarating. And I was there working on cases that were only a year or two old from the Kosovo conflict. Weapons offences, terrorism charges, war crimes allegations. And it brought me right back to the days of when I was studying Schindler's Ark and I should have said also the Yugoslav war, which took place in a country where I'd visited when I was a student before it had all kicked off in the early 90s. So from there I realised that's where I wanted to go. I wanted to do something meaningful, something that would connect me to my idea of what a lawyer could do with this motivation to want to do better things, make the world a better place. Again, hearing myself repeat that is very idealistic. I did that for a year and a half. In the meantime, I'd met my partner, came back to do a master's in the topic that I thought I should be an expert in, human rights law and humanitarian law, and then went back to do more war crimes prosecution work in Cambodia. So I was one of the first prosecutors in the Khmer Rouge Tribunal in 2006. So I was there in Cambodia, lived in Cambodia for 3 years, and again found that incredibly rewarding. Although my idealism, I can talk about this if you'd like, took a bit of a hit whilst I was there. Because of the realities of these big war crimes trials being that, well, what does justice look like? Are you really giving justice to those victims that were so badly affected, those millions of people who were killed, tortured, whatever, by putting one or two, a handful of people on trial, and nothing happens to the people that did the killing, the people that wielded the machete or pulled the trigger on the AK-47. And the bureaucracy of a massive organisation like the UN kind of smothers to a greater or lesser extent the idealism, or at least for me it did somewhat. But it nevertheless was a huge privilege to be able to stand up in court and cross-examine somebody that had been accused of all these terrible crimes, and I felt that was what I was the pinnacle of my career in a way. There and then, and I think I was still idealistic then, and less so now. So what happened after then, I came back, we started a family, and we decided that it wouldn't be conducive to a family life to do all these war crimes prosecutions in countries that were far-flung and not always that safe.
Sure.
But nevertheless, I kept alive this consultancy where I would go to post-conflict zones and train judges and prosecutors and defense counsel on fair trial rights. So I went to Lebanon, Uzbekistan, Sierra Leone, Georgia, lots of different countries where I met ordinary lawyers trying to do their jobs in very difficult situations.
Right.
But it wasn't really something that I could keep doing and still be a family man.
Sure.
and to have, to fulfill my responsibilities and my desire to be with my wife and my daughter. And so I sort of talked to a colleague who I was working with on one consultancy in Myanmar, a country I know really quite well. And they said, well, what about academia? And you can follow your passion of going back to this area of law. You don't have to go back to the burglary trials in Leeds Crown Court or Bradford.
Right.
And so I took it up and became an academic, first of all, at Liverpool University, and now for nearly 4 years here at Leeds.
Right. That's what a fascinating story. And as an academic, have you been kind of taking the opportunity to think more deeply about things that sort of, I guess, troubled you, or, were kind of complexities of the way you approach law as a practitioner?
Absolutely. I was always struck when I practiced law how influential certain types of people were, certain lawyers were, and their overwhelming personalities and driving motivations would shape the office, whether it be the office of the prosecutor or a defense office, or the way a tribunal is run.
Right.
And maybe I'll tell you another sort of reflection as well. When I got to Kosovo, the first time I'd ever stepped outside our jurisdiction in England and Wales, and I'd been used to barristers. I prosecuted and defended myself. That's what most people do, certainly when they're junior. Right. And I became exclusively a prosecutor in Kosovo. And I met my fellow prosecutors who were from different jurisdictions, American prosecutors in particular. I mean, there are many others, and I was really quite taken aback by their much more zealous pursuit of a conviction in a way that I felt was overstepping the mark. I thought that it was a conviction at all costs. I know I've spoken to many colleagues since then, and they'll deny that that's what they do. Right. But it came across to me as somebody that was not just being a minister of justice, but you were going to get this guy come what may.
Right.
And I had a problem with that because I was trained in this idea of you've got to obviously do the utmost to bring people to justice within the bounds of the law, within the bounds of what is proportionate and reasonable. Otherwise, if you are undermining the fairness of the trial, then you crush the legitimacy.
Yes.
And that is something that I had a real problem with. So I've sort of taken that as a concept and I've tried to explore it. I had a big project that you alluded to a few minutes ago where I interviewed a lot of my colleagues, former colleagues, and people I used to know and they used to know who were working in war crimes tribunals. I ended up interviewing 60-odd lawyers. Yeah. And about this concept of cause lawyering, and I can talk a bit about this in due course.
Yeah, so what do you mean by cause lawyering?
So the concept of cause lawyering was popularized by two American academics, Austin Surratt and Stuart Scheingold, and their ideas came from how the practice of lawyering had become divorced from morality. So people would be a corporate lawyer during the day; they'd be working for the man, for making dollars for the shareholders, whereas that wouldn't be necessarily very consistent with their own morality. They might be liberal, they might have environmental designs, or they might have other ways of expressing their political life, but their lawyering was almost antithetical to that.
Right.
And so Surratt and Scheingold coined this idea of cause lawyering, where a lawyer wouldn't just become or be a client lawyer. So they wouldn't just be a hired gun. Right. So anyone in any case could could hire you and pay you money, and you could do your job, and you do it to the best of your abilities, to be the zealous advocate.
Yes.
Lawyers who were cause lawyers would instead pick and choose those cases that were consonant with their own political, moral, ideological beliefs.
Right.
And things are different in America to here. They don't have the cab rank principle that we have here at the bar.
So let's explain what the cab rank principle is.
Sure. So as a barrister, you have to take any case that comes your way. The first case off the rank, you have to take. You can't pick and choose dependent on whether it aligns with your ideology, morality, whatever. As long as you are sufficiently qualified to do it, then you have to take the next cab off the rank. The reasoning for that is that otherwise, what would happen to those people who were accused, mind you, not convicted yet, accused of very serious crimes or those crimes that people would consider to be beyond the pale? What would happen to them? They wouldn't get any form of representation.
Yeah.
The cab rank rule protects anyone that might be accused of that. And of course, also being accused of something isn't the same as being convicted. Even though obviously being in the dock and being accused and having been arrested or arraigned for it puts you almost in a very difficult position from the start.
So presumably the thought behind that is that it allows lawyers then to be very kind of focused on the interests of their clients, right? So it's a kind of rule or principle, which serves a sort of a higher or kind of higher principle of the public interest or something like that. So there's a kind of public interest in the law working in a certain way, everybody having access to a good defense, a high quality defense, something like that. So you have a principle which allows lawyers to be very focused on doing a really good job for their client, and the kind of broader structure allows that to then serve the public interest.
Yes, I mean there are other types of typologies and categorizations of lawyers. I'm not going to go into all of those, but like public interest lawyering, human rights lawyering, social justice lawyering, they could all come arguably within a cause lawyer typology. But the distinguishing feature between a cause lawyer and a conventional lawyer is that a cause lawyer will take cases purely to advance their own political or moral belief.
Yes.
It is you can't accidentally be a cause lawyer. It's a very intentional practice.
Yeah.
You intend to take a particular type of cases out because you believe very strongly in, I don't know, gender justice or immigration rights or whatever it be.
Yes. Right. Okay. And you've been interviewing lawyers about, their motivations for becoming lawyers and their motivations for the way they approach their work with this kind of idea of cause lawyering in mind, right? So kind of thinking about what's the distinction between cause lawyers and conventional lawyers, and how does that play out in different areas of law?
I have. So just to cycle back to what I was saying about this first meeting I had with a US prosecutor.
Right, okay.
And how I was quite taken aback by the zealousness with which he approached his job, which I thought overstepped the mark. When I was a prosecutor in Kosovo and in Phnom Penh, I hadn't heard of the term cause lawyer. It was only since being an academic. But I was always had it in the back of my mind, is this really what we're about? Should we just be getting a conviction at all costs?
Yeah.
Or near as damn it? And then when I spoke to this now really good friend of mine who's an academic in Belfast, he talked to me about this idea of cause lawyering. And it suddenly a light bulb went on over my head. This idea, are international prosecutors, can international lawyers also be cause lawyers? Is that the explanation for this zealous, very driven, very sort of hubristic approach to the law?
Right.
And so I interviewed 60 prosecutors, or in total, prosecutors, defense, victims lawyers, and one or two judges, with this idea in mind to tease out people's motivations for being a lawyer, what they would do, what they wouldn't do to prosecute a case, whether people thought that being a cause lawyer or a conventional lawyer was a definition that they could see themselves in or not. Was it a bright line? Was it blurred? Was there a spectrum? And how that importantly, I think, how being a cause lawyer or not influences the way the law is practiced and shapes the institutions within which law operates. So I had some really interesting. I mean, it wasn't a representative sample. This was a qualitative rather than a quantitative approach. So we've always got to be careful as academics. I now know that you can't say, and therefore all prosecutors are like this or all defense lawyers are like this. But I had some really interesting commonalities that came out of the stories.
Yes. So I think, like, to me, the way to characterize qualitative research versus quantitative research is qualitative research can give you insights, right? So it can kind of give you a story about like particular lawyers' motivations, and whether that's representative of all lawyers in that category. You can't answer that with qualitative research, but it can kind of give you an interesting insight into at least the way this particular person in front of you is thinking.
Yes, exactly. And one of the things that really struck me, certainly about the people that, if they wouldn't call themselves cause lawyers, might actually fall within the typology.
Right.
Because people were understandably reluctant to be pigeonholed by this relatively new academic who'd formerly been one of them and now become the poacher, or was it the gamekeeper? I'm not sure. Trying to shove them into one category or the other. I hope I didn't do that. But this idea of something that was connecting to them, that connected to me in terms of the idealism of legal practice. Something that was, I did this with all of the NVivo software that we use. This idea of meaningfulness and the sense of belonging that you get through your work that is consistent with your values. And that came through quite strongly with those people who would align with or be forced, maybe some more begrudgingly than others, to concede that they were cause lawyers.
Right. Okay.
Just
to clarify, so were the interviews all with lawyers who were working in their kind of international criminal law?
Yes.
Yes. Okay. So you weren't talking to domestic lawyers, would it?
No. So domestic lawyers, cause lawyering has been not exhaustively done, but certainly it was done quite a long time ago. I guess the 90s and the noughties were the heyday. But nobody had sort of looked at this idea, well, is there something to be said about the direction of international justice and the people that advance it and seek to prosecute it, in terms of what they are personally doing for themselves or for the wider community?
I mean, it seems like an obvious move, right? I mean, given the way you described your own motivations for joining that kind of area of law, to wonder whether that's kind of broadly representative. So, I mean, did you find that people had stories similar to yours, that people did join for idealistic reasons in the same kind of way?
A lot of people did, not everybody. There's a really interesting sort of wrinkle in some of the things that I found, an interesting commonality, that there had been quite a large minority of prosecutors that I spoke to. And again, this is not statistically significant, but it was so unusual for me that I thought I'd better mention it, who had previously been corporate lawyers. So they'd initially trained as a corporate lawyer, and they made a lot of money or made a lot of money for other people. And either sooner or later they fell out of love with their job or their reason for doing the job, and they turned to doing something that was potentially exactly the opposite, which was seeking justice for the downtrodden, the victims, all of that. And I'm ambivalent about cause lawyering in some ways. I wouldn't say that I'm a dyed-in-the-wool cause lawyer nor a conventional lawyer. I think I have aspects of both. But I see there are some problems with cause lawyering in international criminal justice where you fail to sort of take into account the things that we lose when you're a cause lawyer on that stage. And that might be the sense that defense rights are important for the legitimacy. You need to respect rules of process and due process and fairness.
Right. Okay. Yeah. So, I'm sure we'll get onto that in a moment. So I think that's a really interesting area of the research. But I wanted to ask. So you interviewed prosecutors and defenders, is that right?
Prosecutors, defense lawyers, and victims lawyers.
Right.
So you might not be aware that in the big international courts, certainly in the International Criminal Court in The Hague, which is the permanent international criminal court.
Yeah.
Unlike the ad hoc tribunals that come and go, Yugoslavia, Rwanda, Cambodia, Sierra Leone, they're now have finished their work. But the ICC in The Hague has a victims office where those who were victims of the crime can apply for legal representation. Their victims' lawyers can ask questions, can present evidence, can call their client victims to give testimony in the trial. So I interviewed some of those as well, because I was interested to see if there's much difference or any difference between the prosecutors and their motivations and the victims' lawyers and theirs.
Yeah. And did you find that there was?
There was not much difference. There was a sort of a big similarity as I probably would have expected. But I didn't speak to enough. I'd like to have spoken to more victims' lawyers to be able to be more confident in saying, well, victims' lawyers are even more this or even less that. But it was certainly there were some certain commonalities of cause lawyering among the victims' lawyers.
Right. Okay. I don't think we've really answered this question about kind of international criminal lawyers. But do you think international criminal lawyers are more likely to be cause lawyers than domestic lawyers? I mean, obviously you can't kind of answer that quantitatively, but is that your sense that I see that international criminal lawyers tend to be more motivated by these kind of higher ideals?
I think to go into an international organization from your comfortable domestic practice, you're going to have a reason to do that.
Yeah.
And it's either going to be, and I classified these different motivations in my coding data.
Right.
So there was an emotional reason because people really believed that this was consonant with their own morality, ethics, or whatever.
Yeah.
Because there was professional curiosity, because it's absolutely fascinating, and it's a much less developed area of law. It's been rapidly developing since the 1990s, since the first post-Second World War tribunal of Nuremberg happened in 1947-48. There was a huge hiatus because of the Cold War. The next one wasn't until the mid-90s with the Yugoslav tribunal. So it's international criminal law has only really started to expand dramatically since the 90s, which for a body of law, for law as a body is very recent. Yeah. So it's fascinating to be involved as a professional in that field. Yeah. So there are people that were just curious about it. Yeah. And there were those who liked the status. Yeah. You know, it's and I had a bit of that as well. You know, being absolutely blunt. I came back from Kosovo or Cambodia to home for Christmas. What have you been? You've been doing what, Alex? You've been. Come on, we've got James Bond here, and it's it's crazy. But I know for myself, and I'm speaking to other people, there is a sort of a seduction in that sort of sense of you're doing something fascinating, a bit sexy and interesting, and you're flying on helicopters and interviewing. It's human nature to admit that, although not everybody would admit it. And I sort of divided that into the sort of sacred motivations of the higher good, the common goal of humanity, justice, equality, all of that. And then there's the profane motivations. You've got the status, the ego. Ego plays lawyers and ego, it's toast and jam, isn't it? It's they go together really well. So there are lots of motivations that came out of the discussions, and I was interested specifically in how those motivations formed their professional careers as well. Right, yeah. It's really interesting. One of the things that I found really interesting reading your paper was the way you talked about people for whom cause lawyering or, the ideals that constitute the cause or whatever become part of their core identity, or that's how they describe their motivation. So how would you characterize that? What does it mean for, cause lawyering or whatever to be part of somebody's identity in that way? I was very influenced by, there's a Finnish academic called Lisa Malki, and Lisa writes about humanitarian aid workers and the people who they help. And her argument is that this relationship between aid worker and refugee or whoever that they're helping is not just one way. It's not just the aid worker dispensing largesse or help or aid or whatever to the the poor person in a conflict zone.
Yeah.
The poor person in a conflict zone is also affirming the desire that the humanitarian aid worker has to make sense of the world, to be in the world and do something more meaningful than might ordinarily be the case. I think that happens with cause lawyers and other international criminal lawyers who are maybe not cause lawyers as well. I think people have this need to feel connected to something.
Yeah.
And the idea of having, a degree of overlap between your beliefs and your career, not having them so totally separate, is something that a lot of people really strive for.
Yeah.
And now we have an incredibly complicated world, very depressing daily news that comes out. People are always sort of seeking meaning and how they can somehow get a handle on it. And if they can do that by channeling that desire to be in the world and to try and help the world through being a lawyer in these sorts of spheres, I think that really plays into their identity very strongly.
Yeah. It's really interesting. I think it's something that goes through all the professions, actually. So a lot of my work involves kind of working with professionals in a variety of areas like engineering, and at the moment talking to some health and safety practitioners. And this question often comes up of, as a professional, on the one hand, you are likely to be, you're going to have some kind of identification with that role. You're going to kind of take pride in the fact that what you're doing contributes maybe to the public good in some way, or to some kind of ideal that sort of transcends the everyday kind of reality of what you're doing. On the other hand, you're a member of a profession, and, for example, your clients or the wider public have a right to expect consistency from professionals, right? So there's a question about like how much you should be bringing your own personal values and your own personal ethics to the role, and how much you should be just kind of subsuming those within a set of expectations which are constituted by the profession itself and which people have a right to expect.
Completely.
And that kind of creates a bit of a tension.
It really does. This concept of professionalism in the law, certainly among lawyers who work in our jurisdiction in England and Wales, they would consider it to be, the vast majority of people I've spoken to at least would say it would be completely unprofessional to put yourself in a case. You must take emotion out of it. You're not there for yourself. You're not advancing your own. You're doing your best for your client if you're defending, or you're doing your best for the state if you're or for the Crown as it is if you're prosecuting. And I argue that it's not as black and white as that. I say that emotion does come into it, and inevitably comes into it because we're working with human beings. Your own emotions will be exercised by the things that you see and the things that you do. And also those people that would say, I'm a dyed-in-the-wool conventional lawyer, there's no way I could ever be a cause lawyer. Being a cause lawyer is totally unprofessional. Those people would also use emotion in a courtroom.
Right.
They would do that in a speech to the jury, in talking in a particular way. In even doing a speech to the judge, a plea in mitigation, where you're trying to persuade the judge not to send your client to prison for the 14th time they've taken heroin and gone and burgled somebody's house. So emotion plays a part, and this is in legal decision making. I'm on a bit of a topic here because I think this is only just being accepted around the fringes, that cognition isn't the only factor of legal decision making. Emotion also plays a role in this. And but it's always been seen as being unprofessional, and that's the big, coming back to cause lawyering, conventional lawyering, that is the big debate. Right. It is unprofessional to be a cause lawyer, says the conventional lawyer, and the cause lawyer would say, well, you have to follow your morality, your gut feelings. Where do I stand on that? I can hear the arguments of both of those. I think there's a time and a place for both. It's not easy to do, and it kind of explodes really the role of professionalism if you start to bring in concepts of cause lawyering. I know. I can already hear some of my former colleagues saying, "What on earth are you talking about, Alex? So you've forgotten your training at the bar." But I think really when I talk to my own students now who, come to see me in my office hours, and I say, so you want to be a barrister or a lawyer? Why do you want to do that?
Yeah.
Because you've got to have an answer to get through the interview. Yeah. And I hear the same things they're saying to me that I would have said were I asked in the 90s.
Yeah.
So there's still something drawing people to the law.
Yeah.
About doing good, helping people, being part of something bigger that hasn't been completely extinguished. And I think what might be good about, what I think is good about cause lawyering is the drive that you get from the consonance between your personal motivation and your job. And you will run through brick walls if you believe what you're doing is right for you and right for the people that you're working for. Yeah. And the amount of pressure that people are under in these big tribunals and the big cases is immense. We're working very long hours without breaks. Burnout is very common. Yeah. And the toll on lawyer well-being, which is another big area, is well known. Yeah. So to get through all of that, a dollop of cause might actually get you through. Yeah. Whereas just being conventional or being functional about it may not. But then I can see the other side. I can see how too much of a cause will perhaps make you hubristic, as I've used before, the word before, will make you lose sight of the perspective. After all, you're only one person doing a job.
Yeah, really interesting. So the way you talked about the role of emotion then in legal practice, I thought was really fascinating. So you were talking about, a conventional lawyer is likely to use emotion in the way they're kind of making a case in a court. Right?
Every lawyer, I'd say.
Yeah. But I suppose there's kind of different ways to think about what they're doing there, right? So, I mean, on the one hand, they may be being emotionally manipulative, right? They may be kind of playing on the emotions of the jury or whatever, but they're not kind of making a sincere expression of their own emotions. But in some cases, they might be making sincerely expressing their own emotional kind of reaction to the case, but with the intention of communicating that to other people who are involved in the trial, who they need to get on side in order to kind of...
So what you're identifying is a concept called emotional labor.
Right.
So an emotional labor is where somebody for a wage performs a job that you are required to either conceal or project a certain emotion that may not be consonant with your own, may or may not be consonant with your own. And it started off back in, I think it was the 60s or the 70s, where a scholar was talking about air hostesses.
Right.
And no matter how awful the passengers are, you've got to present this very smiley, professional approach to make sure they have a good flight. Yeah. And emotional labor among lawyers is something that I'm really quite interested in. And a colleague who I've been working with on a paper coming out from my data, Shalon Westerby at Sheffield Hallam. So I've been working with her, looking at the data that I found from my research, because what was surprising to me, I'd set out to research cause lawyering specifically, but what really came out was emotion as well as cause lawyering. But I hadn't gone into it thinking that emotion was going to play. I hadn't thought about emotion as a theme, but it really came out as a big theme. And so me and Shalon are writing in the process of writing a paper about emotional labor among war crimes lawyers and how that shapes their well-being and what it might say about the creation of the courts and the law.
Yeah, that's really interesting. But I suppose what the worry might be with too much of a kind of emotional investment in your job, which might be generated by kind of too much of a cause lawyering outlook, I suppose, is that, that it might undermine your commitment to the kinds of professional principles that we were talking about before, right? So if somebody's just so emotionally invested in securing a prosecution, for example, that they end up cutting corners on the things that they have, professional duties to do in order to ensure that a fair trial
exactly
ensues.
Yes. I mean, I had of all of these people that I interviewed, the 1,000 pages of interview transcripts I've got, there was only one tiny example of where somebody might have done something wrong or turned a blind eye to something as a result of being a cause lawyer. And that was where a prosecutor or a defense lawyer was saying that a prosecutor might have not disclosed all of the evidence in the fullest of sense, or disclose every piece of evidence because they were so keen on getting a conviction. So I have no evidence to suggest that this is rampant and cause lawyering causes due process rights to be trampled all over. But I take the point absolutely. Your professional duties are to the court and to due process. And if you're just concentrating on getting that conviction at all costs or pursuing your cause at all costs, then you might be blind to your professional duties. And that's the big criticism of cause lawyering.
Okay. Another criticism that people have made is that cause lawyering fosters unreasonable expectations, right? So, people talk about being on a mission to kind of end impunity in this kind of international criminal context. I suppose I was reading that stuff, I was thinking, well, I can see that might be a problem, but on the other hand, even if an ideal is kind of unrealistic in the sense that it can never actually be fully attained, it might still be a valuable thing, right? It might still be something that you can aim at. You're never going to completely end impunity, but if you chip away at impunity to some degree, then that's still a valuable thing to do, right? So,
sure, it's a rallying cry. It's something to work towards. People would say, and the major proponents of international criminal justice and tribunals would say absolutely that we have to aim for these ideals. So it's not fair to criticize people for them. And I would say, well, I think we have to be mindful of what it sounds like as well. And a dose of humility, I think, is useful for lawyers, even though it doesn't always go hand in hand with a zealous advocacy and the need to prosecute as firmly as possible. But the over-promising is something that international criminal law does very well, or rather very badly. So I alluded to this at the beginning. So if you're putting on trial, let's take the Cambodia tribunal, for example, where I worked for 3 years. In the end, there were a handful of people that were put on trial, and there were only 3 convictions. I can't remember how many hundreds of millions of dollars the court cost. And a lot of people say, was it worth it? What could you have done with those many hundreds of millions of dollars for the poor people whose family members were murdered and tortured and who now still live in poverty?
Right.
There's a whole scope of what's called transitional justice.
Right.
Coming to terms with the past. How do you deal with the past? Putting people on trial, putting a handful of the senior leaders on trial is only one tool in the box of transitional justice. You could have truth and reconciliation commissions, which have their detractors and their supporters too. You could have economic justice. You could have disarmament, reintegration and rehabilitation, memorialization, truth-telling. All those sorts of things are part of society coming to terms with very bad things happening. I think that's probably where I would... If I was forced to say, where are you now on all of this? Right. I certainly would not abandon international criminal justice. No. Nor obviously domestic justice. Domestic justice couldn't function without a system of. The domestic society could not function without a system of justice to enforce the rules. But at the level of international criminal justice, where there is no enforcement mechanism. There is no world police to go in and arrest Vladimir Putin or Netanyahu, whoever, to bring them to justice. So it's very much more of a sort of voluntary system where people try and advance the rules through a piecemeal approach to bringing people to justice. But that is totally flawed because it's not been signed up to by everybody. So America, Russia, China, India are not signatories to the Rome Statute, the International Criminal Court. There'd be real problems if, there was enforcement of that nature. How would it affect conflict? And I think it'd be very difficult. So a degree of humility about what it can and can't achieve is something that I say is overdue.
Yeah. Okay. Right. So we're pretty much running out of time, but I suppose I've got a kind of unreasonable closing question, which is just, given all you've said, like ultimately, do you think cause lawyering is a good thing or a bad thing? And, what's your answer?
No, I think it's good. I think it's good that it exists. I don't say it should be the dominant mode of practice, but I think it holds a mirror up to conventional practice, and it perhaps shows conventional practitioners what they might lack, and that's a connection between morality and the law. Some people would say that those should be two totally separate things. Do I think cause lawyering should be the only way we practice law? Absolutely not, for the reasons that we've mentioned. The hubris, the unrealistic expectations, the perhaps difficulties with professional codes of practice. But I think we could learn something by a more frank exchange between cause lawyers and conventional lawyers. Just because they've been professional codes of conduct for centuries doesn't mean that we can't change them or can't look at ways in which they can be adapted to our new understandings of the way people work, the way people take decisions. As I said, emotions, the influence of emotions on legal decision-making are only just now, with the benefit of evidence from neuroscience, coming into force. And that hasn't really touched domestic law and legal decision-making, and I don't think it will for many years to come. But I think it's important to have a dialogue between the cause lawyers and the conventional lawyers, and I think it's important to keep those discussions going. Yeah.
Okay. Well, that's brilliant. Alex Batesmith, thank you so much for being on the podcast.
Thanks. It's been a pleasure.
If you enjoyed this episode of Ethics Untangled, please like and subscribe and recommend us to your friends. The podcast is edited by Mark Smith at Leeds Media Services, and our music is by Kate Wood. Ethics Untangled is brought to you by the Idea Centre, a specialist unit for teaching, research, training and consultancy in applied ethics at the University of Leeds. We offer master's programmes in healthcare ethics and applied and professional ethics, and PhDs available full or part-time and face-to-face or by online learning. We also offer consultancy and training services for business and the professions, including help with the difficult ethical issues faced by your organisation, commissioned research projects, and online or face-to-face CPD. If you'd like to find out more about these or any of our other activities, please visit our website at ahc.leeds.ac.uk/ethics.